Hello. Good evening, ladies and gentlemen. Please take your seats and also please switch off your mobile phones. A warm welcome for today's inauguration program. I extend a very warm welcome to all the honorable judges, master trainers from different parts of the country and the mediators. I request Mr. K.D. Nag, Joint Secretary of the Mediation and Conciliation Organizing Committee, to escort the Honorable Chief Justice to the dais. I request Mr. Yeshwardhan Swaroop to please escort Honorable the Senior Judge, Honorable Mr. Justice Ramesh Khanna to the dais. I request Mr. Ramraj to please escort Honorable Mr. Justice A.R. Masudi, Chairman of the Honorable Committee, to the dais. I think it's 4 o'clock and Honorable Mr. Justice L. Nageshwar Rao, Judge, Honorable Supreme Court of India, and the Chairperson of the Mediation and Conciliation Committee, Supreme Court, is likely to join in a few minutes.
He will join.
I'm sorry, Your Lordship. A very warm welcome in today's function. Honorable Mr. Justice L. Nageshwar Rao, Chairperson, Mediation and Conciliation Committee, Supreme Court, Judge, Supreme Court of India, the Chief Guest of today's function, Guest of Honor, Honorable Mr. Justice Rajesh Bindal, Chief Justice of our High Court, Honorable Mr. Justice Ramesh Sinha, Senior Judge of Lucknow, Honorable Mr. Justice A.R. Masudi, Chairperson of the Committee, Honorable Members of the Committee for Mediation and Conciliation, other Honorable Judges, Master Trainers, Mediators, Members of the Registry. It's indeed a pleasure to welcome you all for today's inaugural function for the 40 hours mediation training to be imparted under the aegis of the MCPC. I may point out that a Mediation and Conciliation Center at Lucknow was inaugurated on 22nd of September 2007 by Honorable Mr. Justice Markande Karju, the then Judge Supreme Court of India, and Honorable Mr. Justice H.M. Gokde, the then Chief Justice of the Allahabad High Court. Initially, there were 87 mediators who were trained in 2 batches, the first and second batch. The master trainers who came were from different parts of the country and very well-known trainers. They were Mr. Niranjan Bhatt, Mr. Shriram Pachu, Mr. Brij Bihari Das, Mr. Sadhma Ramchandran and Mr. J.P. Singh, amongst others. Thereafter, a 20-hour refresher training program was also conducted by the MCPC in the year 2017, in April 2017. The Mediation Center has reached a long way. Initially, there were very few mediations referred to the Mediation Center, but now we have over 4,000 referred mediations from 2007 to 2022, out of which around 1,200 are successful. About 2,000 and odd cases were not successful, though they were tried very hard by the mediators, and around 450 cases were non-structures. We still have about 283 pending cases in the Mediation Center, which starts from the year 2020 to 2022. Last 5 years, the success rate has been amazing because it is now around 40%. Initially, the success rates were very less, but now we have a good success rate of about 40%. Very important matters are now being referred to mediations, though still initially we were only getting matrimonial disputes more in number, but now very important cases have been referred by honorable judges to mediation, and one important matter was the Lucknow Metro Rail Corporation, which was assigned to a noted mediator in the Mediation Center, and that resulted in a success. Another matter where the state government and the child welfare schemes where the ambulances were running, but there was some dispute, the matter was referred to mediation. It was a successful mediation because thereafter the company got 47 crores and the government got the facilities of the ambulances. Also, some other company matters, insurance matters have been referred to mediation. Even property matters are being referred to mediation. In a very recent mediation matter where the dispute was between a father-in-law and a daughter-in-law regarding the property, how it will be divided, that also resulted in a success by both the parties coming to the settlement table and taking their shares. So mediation is always a win-win situation. It leaves less heartburns, and this is how our mediation center is working very efficiently. I will also like to point out that a lot many learned mediators have also been elevated as judges of the High Court. Some of them I can just name: Justice Rakesh Srivastava, Justice Rajesh Singh Chauhan, Justice Alok Mathur, Justice Jaspreet Singh, Justice Ravinath Tilhari, and Justice Subhash Vidyarthi. So, apart from doing very well on the mediation side by settling disputes, our learned mediators have also adorned the bench, and I think the list will go on. This mediation center has also been very instrumental in coordinating with the Ram Manohar Lohia National Law University by holding moot courts where the learned mediators have participated as judges. And the first inter-university moot mediation competition was held in Dr. Ram Manohar Lohia National Law University, and 17 media advocates participated. Mr. K.D. Nag was instrumental in imparting training which was organized by the UP State Legal Services Authority. Mr. Y.S. Lohit has on and off delivered lectures on mediation in different districts. A seminar was organized by the Mediation Center, High Court, Lucknow on 21st August 2011, where Mr. Yashovardhan Swarup was instrumental in getting this convened. And the topic was alternative dispute redressal vis-a-vis mediation, its problems and prospects. Presently, there are 50 mediators who have to be given this 40 hours mediation training under the aegis of the MCPC, Supreme Court of India. And now I request the honorable dignitaries to please come and light the lamp. Nageshwar Rao, chairperson of the MCPC, to please grant us permission to go ahead with the inaugural ceremony by lighting the lamp.
Please do.
Thank you. To come and present a bouquet to the learned dignitaries, I request Mr. K.D. Nag to present a bouquet to Justice Nageshwar Rao. You can please accept this because just 2 minutes. I request Justice Nageshwar Rao to accept our bouquet, and I request the Honorable Chief Justice to accept the bouquet on your behalf. So now, please. Now I request Mr. Yashovardhan Swarup to please come and present a bouquet to Honorable Mr. Justice Rajesh Bindal, the guest of honor for today's function. Just 2 minutes. I request Mr. Ramraj to come and present a bouquet to our Honorable. I request Mr. Y.S. Lohit to please come and give a bouquet to Honorable Mr. Justice A.R. Masoodi, chairperson of the Committee for Mediation and Conciliation. Person of the Mediation and Conciliation Committee, Honorable Mr. Justice A.R. Masoodi, to give his welcome address.
Good evening, everyone. It's a matter of privilege and honor for us to see Honorable Justice S. Nageshwar Rao, Judge Supreme Court of India, to be with us today in this inaugural ceremony for training of mediators on this auspicious day, which is famous for Mother's Day. About our chief guest, I need not introduce him, yet I cannot escape saying that the senior advocate, the renowned senior advocate, Mr. D.P. Rao, as and when I had an occasion to meet him, he was dear to all those who believed in the hearing of matters, in-depth hearing of matters. And Justice Rao was one of the dearest lawyers whom late Mr. P.P. Rao always spoke. This was the eminence of our chief guest while he was at the bar. An eminence in cricket also, which all of us know. And after he has adorned the chair of a Judge Supreme Court of India, he needs no introduction for the landmark judgments which he has rendered. His words of wisdom for the promotion of this mediation center shall certainly be treasured, and it shall benefit the growth of this mechanism of redressal and will go a long way. We welcome you, sir, and we extend our assurance that the words spoken by you shall not go waste within the premises of this mediation center and shall benefit one and all. Our Honorable Chief Justice is also present amongst us today. I have had a few occasions to meet him. My personal understanding is that he is one of the leading architects of reforms which this institution requires so eminently. When I see at the medical profession and comparing it with the legal profession, two difficulties I come across. In the medical profession, the difficulty of treatment, diagnosis and the remedy. So is the situation in legal profession, in our judiciary. In medical profession, diagnosis is very difficult, and the medical science has expanded its growth and research in diagnosis so as to make the remedy easy. For us, diagnosis of the problems is easy, but the remedy is difficult. I am happy that legal fraternity is making an endeavor to explore new ways and means of remedies so as to bring the facility of justice at the doorstep of a sufferer. Our Chief Justice is leaving no stone unturned in that direction, and this mediation center is one of the beneficiaries of that. I cannot skip over the role of my learned brothers present in the audience, without whose contribution the mediation center, rather no mediation center can work. We are looking up to the managerial part. They are the referral courts, and I believe that the faith in the referral courts is the faith that sustains the existence of this mediation center. I hope and trust that this mediation center builds an untiring mechanism for the redressal of disputes so as to win the faith and trust of our referral judges that any matter referred to the center will come with a resolution, with a remedy, and will rest the controversy at rest. I assure you all that for whatever time we are there at the helm of affairs, this reference of yours will not go unattended, and it will see the most effective measures which this mediation center will take. Lastly, the mediators for whom this training program is organized, you are the bedrock of this redressal mechanism. We have talked much about the role of mediators But what fears us is the conflict of interest. It is for removal of certain doubts about the conflict of interest that this training program is organized. A mediator struggles within when he has a role to play, diverse in his professional career. He is an independent lawyer, foreign adversarial litigant. He contributes his service in the arbitration matters, and then he also discharges his duty as a mediator. The three roles are at variance. This struggle from within poses a challenge to the mediator as to what technique will he apply in one case and how differently will he behave in the other. This training program will tell you at least we had aimed this service to be pro bono, but over a period of time we have realized that some financial support may also be there to compensate the services rendered by you. This struggle from within has to be balanced so as to see this mediation to be a successful medium of redressal of grievances. This you have to train for yourself and give outstanding results so that you also develop as an independent course of justice, for the reason that all of us here must be reminded of that saying of Martin Luther King, that injustice anywhere is a threat to justice everywhere. I am sure that the contribution of this three-layer system goes a long way to bring fruitful results, and that faith in the mind of common people who every now and then are faced with some difficulty or other. Giving me this opportunity of introducing the dignitaries and talking to you about the mediation, I thank you all. Thank you very much.
Now I request the guest of honor, Honorable Mr. Justice Rajesh Bindal, Chief Justice of Allahabad High Court, to give his address.
Honorable Mr. Justice L. Nageshwar, Supreme Court of India, Chairperson, MCPC, my sister and brother judges on behalf of the dais, Ms. Bulbul Godial, Senior Advocate and Secretary of the Mediation and Conciliation Organizing Committee in the High Court at Lucknow, learned master trainers, learned mediators, distinguished guests, ladies and gentlemen. First of all, I am thankful to Honorable Mr. Justice Nageshwar Rao for sparing his valuable time to be with us online, because he had certain programs scheduled at Delhi also, but still he readily accepted our request. We are thankful to you, sir. And this is, I think, after a long time, a physical training of 40 hours for the mediators is being held in this High Court. It's a welcome, because after COVID, we all had gone virtual. But now there are positive parts of any physical training which may not be there in the virtual. We all know ADR has different concepts. Arbitration is there, or mediation, these are two major parts. And now more stress is on mediation, because arbitration, but we have felt now there is a lot of delay and cost factor has also been added. That's why more training is being imparted, because training is the most important part for being a successful mediator. As far as the concept in India is concerned, our methodology refers to this whether in Ramayana, Mahabharata, and perchance the birthplace of Lord Ram and Lord Krishna is in state of UP. If we go to Ramayana, Prince Sangad was the mediator. If we see the Mahabharata, Lord Krishna was there. And on failure, we all know the result thereof. So this is how things happen. My brother had referred to that this is a special day, as Mother's Day is also there. And we all know the role of the mother also, how she mediates in the house also. It's not as a mother also, mother can be of small children also, mother can be of like the children of our, for mother we are children only basically. So of our age also. So how she manages things, how different family members, I think she is one of the best mediators without any delay. And second thing, we see the robust system of mediation in our rural areas also. This somehow had diluted now, but earlier times it was very strong. Elders in the village will settle a lot of disputes, that litigation will not come to the court. And in lot of business community also there are mediators. They have their associations which resolve their disputes. And the idea there is that they don't want to go for litigation. They want to continue with the business and with the same person probably later on. So these are the success things. I was reminded of a old story, which we used to study I think in the student time. There was some dispute of custody of a child. And the mediator who was trying to resolve it ultimately offered that all right, I'll cut the child into 2 pieces and both of you take half. I think many of us will recall that story. And the real mother said, all right, give the child to the other because I don't want the child to be cut. So this is how sometimes out of box thinking also resolves the issues. One could find out who was right and who was wrong. How in the court system the people come. In the court system nobody knows who the judge is. They will simply file their case and it will go to the court. Because the people have faith in the system. Unless we develop that faith in the mediation also, make it more institutional. Though there are rights with the parties to choose their own mediators also, this will not be a successful thing. There are many people who love litigation only. That we especially see in the matrimonial cases. Recently you must have read in the Supreme Court one case was resolved in matrimonial dispute where 40 other cases were disposed of along with that. And we all experience in courts also there. There are multiple litigations between the warring parties. So that is more important that we take care of these cases. There are many statutes where the mediation is referred starting from Industrial Disputes Act, that's from 1947. And subsequently also there are provisions in many statutes. I will not name that, I take time in that. But the fact remains that this concept is there. But merely because we have the provisions in the Act will not give us the result. Unless the people at the helm of the affairs, our mediators, our court system also are really proactive in the approach. Only then we can get good result out of it. And for that purpose, I think we need to educate more and more people about this system. What we have experienced in court when sometimes we try to refer a case to a mediator, both the litigant parties will say, okay, the court should only decide the case. Why the case is being sent out of the court, whether the court is shirking its responsibility. So that kind of a argument or arguments by the litigant is there, he says in the court. So probably they don't know about the system or they don't have faith in the system. So that has to be taken care of. Now if we see the mediation also, it may be in 2 parts, pre-litigation also, post-litigation also. Now pre-litigation, there is amendment in the Commercial Courts Act. Limitation also is extended. Cases are being referred, there is no doubt. But somehow the success rate is not that robust. Even though the amendments made in CPC with the Commercial Court Acts are quite means serious effects are there. If somebody takes a wrong stand and all that, a delay is also checked in that. But still, there are cases which are again coming to the fore. And one of the reasons can be that we have lack of trained mediators. Because commercial courts are there at all levels now, at the district level also. There may be disputes with heavy amounts involved at the district level also. So we need to have mediators at all levels and trained mediators. And training, one training may not be good enough. There should be refresher courses also. May not be 40 hours, but maybe little less. Because sharing of views by the experts on any of the issue will further sharpen their knowledge or refresh their knowledge in that. So that is very important. Now I was also thinking that there may be some other statutes also where this can be explored. Maybe the load of litigation on the court is reduced. We had tried one idea, our family courts committee, sensitization of family courts committee had recently tried one idea for having pre-litigation mediation for matrimonial disputes. We had invited applications from the people who wanted to use that facility. It was last month only. And out of about 5870 applications received from prospective litigants who were having some matrimonial disputes, only 1945 parties ultimately appeared before the committees constituted in different districts in the state. And we are happy to share that about 30% cases were resolved, about 635. And we are continuing with this exercise, and this will save, I think, a lot of further litigation. We all know how this matrimonial litigation multiplies. There is order 10 in CPC. But I think there we are also lacking. Our officers are not proactive in exploring that provision while referring the disputes, because that talks about calling the parties in person. And if you call the parties in person in court, you come to know about the real dispute. And then there are guidance from in the judgments of Honorable the Supreme Court which cases are fit for ADR or not. But somehow in that I think we need to sensitize our judicial officers also, that they make full use of it. 138 Negotiable Instruments Act, in view of the latest Supreme Court order, we have already referred the cases which are pending in the High Court. These can be at the trial court level also, because I was seeing the data, there are about 24 lakh cases pending in district courts in the country which are under 138 of the Negotiable Instruments Act. And many of them involve very small amount. Maybe one or two checks in a small loan which may have been dishonest. Now new concept coming is the online mediation. That's online, we all know in COVID-19 pandemic, we could continue with our judicial system, access to justice was available only with the use of technology. So this is one area where I think we need to sensitize and train our mediators also and apprise the prospective litigants of the parties who are coming to the mediation. There are positive and negative points of that. I'm not going to detail because the time is little less, but this online system is being explored everywhere. If you see the Income Tax Act now, a lot of amendments have been made, assessments, appeals and all things, all online. Nobody knows where the appellate authority is there or the assessing authority is there. But still, maybe in some cases you need the physical presence of the parties also to build confidence and also to show your sincerity. I had read somewhere that during training, first day the persons who are thought to be trained feel little bored. The second day they start liking it. Third day they start enjoying it, and then they ultimately find this to be a wonderful thing. So this is how it proceeds. I would only say that this is a great opportunity for the persons to be trained. They should interact more and more with the trainers, clear their doubts, which may not be that possible in online training as it is possible in the physical training, because after the class is over, thereafter also you can interact informally also. And another thing which I thought is very important, because there is a lot of matrimonial litigation, I would request our secretary also, Ms. Bulbul, that she should encourage more and more lady lawyers also to be the mediators, because if the matrimonial case, or there are other types of cases also where the women are involved, probably they will feel more comfortable to share things with the woman if the woman is mediator. So that idea I think should be explored more. With these words, I am thankful to Brother Masudi that he thought of this idea to have this training. I think we are planning to have another at Allahabad also and continue with this process at district level also, maybe by calling the prospective candidates in Allahabad or Lucknow or at different places. Thank you very much.
Chief Justice, for your words of wisdom. Now I request Honorable Mr. Justice L. Nageshwar Rao, Judge Supreme Court of India and Chairperson of the MCPC, to give his keynote address.
Justice Rajesh Bindal, Chief Justice of the Allahabad High Court, Justice Ramesh Sinha, Justice Masudi, other judges of the Allahabad High Court, Ms. Bulbul Godial, master trainers, and other trainees who are attending the training which is to be held for 40 hours. At the outset, I should apologize for not being present physically, as I had already accepted an invitation to attend the valedictory function of an advanced training program which was conducted by Samadhan, which is the mediation center of the Delhi High Court, in the afternoon. Mediation is a method of resolving disputes which provide practical, effective and efficient opportunities to assist in the resolution of conflicts between the parties as an alternate to court-based procedures. Why is it that mediation is being promoted? We have no surprises here. The system is bursting at the seams with the docket explosion and the present strength of judges in the country from the top to bottom not being able to cope up with the large number of cases that are being filed and which are pending for a long number of years. The very concept of alternate dispute resolution was a method to find solutions to these problems. As Justice Bindal was mentioning, arbitration, which was an effective alternate dispute method, has also proved to be more cumbersome than what it was thought at the initial stages. Not any less expensive than court litigation, and also time consuming. Mediation is an answer for pre-litigation alternate dispute resolution working very well, as it serves many purposes. To tell you a little about what is happening in Delhi, Samadhan was started by the High Court Advocates Bar Association of Delhi, and the arrangement was that it would be overseen by judges of the High Court. For the past 15 years, Samadhan has been working very well in comparison to the other court-annexed mediation centers, and according to me, the main reason is the involvement of the bar. I was very happy to note that there are at least 100 cases taken up every day by the Delhi High Court Mediation Center. And they have more than 200 trained mediators who have not stopped with the 40-hour training which they have received, but they have been continuously participating in advanced training which is conducted periodically. The facilities that are provided in this center are very good. And my personal opinion is that without the active involvement of the bar, court-annexed mediation centers would not be giving results. There is some hesitancy in the minds of lawyers that promoting mediation would be at the expense of lawyers losing their work, and for other reasons that the lawyer community is not very well aware of. There is a need to educate the lawyers first that mediation would be promoting the legal profession and putting it in better light than it is at present. The reasons for that are as follows. Mediation, especially pre-litigation mediation, apart from serving the purpose of not adding cases to the docket, would be finding solutions to problems at the initial stage itself when the problems are likely to be solved. Let us take a matrimonial matter. If there is a difference of a dispute between a man and wife, to mediation at the early stages, it would be at a stage where there is no proliferation of cases filed by both parties. As we all know and have experienced, once a dispute starts, there would be a 498 case, thereafter a petition for divorce, followed with another application for restitution of conjugal rights, and followed by custody of children. So the parties would be involved in this litigation, and allegations would be flying against each other with no holds barred. With the help of lawyers, there would be acrimony which would not be so easy to resolve. At every stage of litigation, the parties would be creating more animus against each other, and after a period of time, it might be very difficult to resolve the disputes between them. The same would be the case with any other dispute, like a dispute pertaining to commercial law or a property dispute. The more time people spend fighting with each other, the wounds would become unhealable. So pre-litigation mediation is the best, and mediation would be working well at a pre-litigation stage. Not that even during litigation it can't be tried. I have the experience of matters being settled even at the stage where the Supreme Court has heard matters. In my own court, I have seen that at least 10 to 15 cases got resolved after they were referred to High Court, to mediation centers, as well as the Supreme Court Mediation Center. Mediators are the focal points of this process of mediation, because mediators are those who are a trained person who would be those who would try to facilitate a resolution of dispute between parties. To start with, one should realize that a lawyer is not only a litigator. Litigation is only a subset of lawyering. A lawyer should be a problem solver. A lawyer should be a conflict manager. A lawyer would be a conflict manager because he has the client with him from the initial stages, and it is the lawyer who should advise the client that there is no point in rushing to court for every case. There is every chance of either the entire matter being settled or at least some of the issues being settled before the relationships turn very sour. And if the lawyers start working on these lines, there will definitely be a chance of more harmony and peace between the parties. After parties go to court and after a prolonged battle, a person who succeeds might be succeeding in the case, but the relationship between the parties cannot be brought back. The better system to be followed is keep trying to resolve disputes between parties till there is no chance of the matter being settled between them. Even Mahatma Gandhi said that he was very happy after playing a role of a conciliator in at least 200 cases. He said, I might not have made any money, but that gave him a lot of satisfaction because, according to him, the role of a lawyer is being a conciliator first and not a litigator. There are some shortcomings in the present scenario, especially relating to the role of referral judges, where the mindset of the judges have to be a little different from what it is now. Training and accreditation of mediators and sufficient infrastructure not being available. Starting from the last point, I have seen a note that was given to me about the Allahabad Mediation Center, which was started in 2006. And I heard Ms. Godial say that in Lucknow it was started in 2007. I have also got the data where the number of cases that are referred and number of cases that are decided has been furnished. Apart from that, several programs that were conducted by the mediation centers where renowned mediators of this country have trained mediators in Allahabad as well as Lucknow. I am also happy to note that sufficient facilities are available at the mediation center to make the parties appear before the center, unlike what they see in courts, to make them at ease and let their guards down so that they can interact with the mediators and amongst themselves freely in a congenial atmosphere to find solutions to their problems. However, I am of the opinion that there is a lot to be done in the matter of the change of the mindset of the referral judges, especially at the level of civil courts. I say this because even after the introduction of Section 89 in the Civil Procedure Code on the basis of recommendations made by the Law Commission, we have not really seen the results of the civil judges being active in taking steps in accordance with Section 89 and finding a way of a solution which is possible at the stage before the court takes up the matter in court. there is some reservation amongst judges regarding the use and benefits of mediation. We also have experiences, as I have experiences, as well as the High Court judges who are present here would also have experience that mediation is seen as some sort of a method to prolong the matter. My own experience in the Supreme Court as a lawyer as well as a judge has been, when a matter comes up for admission and if the judge proposes a mediation between the parties, the advocate who is appearing would be in no position to say that he would not make an attempt for mediation. As there is a threat of dismissal of a case looming large, he accepts that the matter can be sent for mediation, and mediation then is only a farce. It's only an empty formality that has to be gone through. After a period of 4 weeks or 6 weeks, we have a report from the mediation center which says that the matter would not be resolved in spite of the best efforts of the mediator. To start with, as I have already said, that lawyers should see this as an opportunity of finding solutions to the problems which I am sure definitely would not have any bearing on their pockets, because there is enough and more litigation in this country, and if the confidence of the people in the institution improves, there might be more and more people coming to the court to get their disputes resolved, which are at plenty. Coming back to the shortcomings relating to referral judges, there is lack of proper training and sensitization about the process of mediation, especially in the subordinate judiciary. On behalf of the MCPC, we have recently resolved to request the Chief Justices of the High Courts to have training programs for judges of the subordinate judiciary. They need not be 40 hours, but at least if there are periodic workshops during the weekends, like Saturday, Sunday, where the judges from the subordinate judiciary are also trained. If they are trained about, to start with, if they are sensitized about the importance and about how the mediation might work, I am sure they would be taking more serious, they will be making more serious efforts in referring a large number of matters to mediation, which can be solved. In Australia and UK, judges are actively involved in impressing upon parties the need to explore ADR mechanisms and impose costs on parties where no genuine efforts are made. As judges sitting in constitutional courts, the High Courts as well as the Supreme Court, I am sure, because this is what I do and this is what most of us do here, the judges initially speak to the parties or the lawyers to tell them that these are matters which can be resolved. We prepare them for mediation, which would go a long way for the parties to decide as to whether they should really give it a try after the matter goes to the mediation. And even in cases where the dispute is not resolved before the mediators, even when they come back, we still try to give it a push. Sitting in the courts, we want to ensure that there is an early resolution of disputes, whether it would be at the initial stages or referring, whether it is at the mediation center stage, but even after the matter comes back. If judges are elected to handle and prepare parties for mediation, it may have grave consequences in the outcome of such efforts. And there is another problem which will be sorted out soon. There is a lack of concrete norms to help judges determine whether a case is suitable for mediation. Might be a judge would be having a doubt as to whether are there any parameters. Would I personally feel for mediation, or whether I would be found fault with for not sending matters for mediation? A scrutiny of the judgment in AFCONs by the Supreme Court would give a clear picture as to which are the disputes which can't be settled, sent for mediation, and all other cases, whether it is property dispute, matrimonial, commercial, there is a good chance of the matter being sent for mediation, and there is a chance of the matter being settled. Insofar as training of lawyers to become mediators is concerned, I would not be speaking about what should be the basic qualities of a mediator which they would be taught in the next 40 hours as to what they should learn, what they should do during mediation. But I should tell you that one of the significant reasons for no settlement is insufficient quality and training of mediators. I have seen initially that courts send matters not only to court annexed mediation centers, but in courts we would see that why not the lawyers sit together and then try to mediate. We would do that because of the confidence the party has in the lawyers. But mind you, mediation is a serious profession by itself. There are so many nuances in the trade of mediation. There are so many things that should be learned by the mediators before they try it. I have a personal feeling that the lawyers would be better mediators than judges. As judges, we are prone to adjudicate matters. And what is to be done in mediation is to facilitate a resolution between the parties. And the mediators would not be speaking too much, but they will be learning the art of patience and hearing from the parties to enable them to reach at a settlement. Once the mediators are trained, after intensive training, they would at least find solutions to some of the issues that arise for a resolution. Unless there is a uniform accreditation framework for mediators across India, it would be difficult to have a basket of trained mediators in this country. We have been slowly facing this problem of finding trainers to train mediators. The number of trainers that are available with the NCPC is only 57. During the last 2 weeks, we had requests from at least 4 high courts asking us to send trained mediators for training mediators not only at the high court level but at the district levels. There is a request made by the Telangana High Court for sending mediators to all the 10 judicial districts of the state. So then when we were working out as to whether sufficient trainers are available, we find that there is a problem. So I would request the court annexed mediation center at the Allahabad High Court and Lucknow to encourage the trainees not to stop with this 40-hour training, but also go through advanced training, and if they take interest in completing a module of the NCPC, we would be having trainers also available. For the trainers, I should say this, ladies and gentlemen, mediation is a very interesting aspect. It is a very fulfilling job. Like a lawyer who is satisfied at the end of the day after arguing his case and assisting his client in succeeding in the matter, wants to settle a dispute, you get more satisfaction than that. Settlement of disputes is our job. Lawyers are the conscience of the litigants whom they represent, and they are the gatekeepers of litigation. Lawyers who are trained as mediators would be playing a very important role not only in ensuring that there is a reduction of the caseload of the courts, but also in ensuring that there is peace and harmony in the society without the disputes between individuals and the corporates being taken to the zenith. There is a Buddhist aphorism which says mediation brings wisdom. Lack of mediation leads ignorance. Know well what leads you forward and what holds you back. Choose that which leads to wisdom. I am sure that this training program, which has been started by the Mediation and 40hrs Mediation Center, will benefit the mediators, and I am sure that there will be many more training programs that will be conducted by the Allahabad High Court, and the number of trained mediators would do well in discharging their functions by following the ethical standards and showing impartiality and ensuring that the disputes between parties are resolved at the earliest. Thank you very much.
Thank you, Your Lordship, for your keynote address and the valuable insights on the mediation and mediation process. Now I request our Honorable Senior Judge, Honorable Mr. Justice Ramesh Sinha, to give a vote of thanks.
Justice L. Nageshwar Rao, Judge Supreme Court of India, Honorable Chairperson, Mediation and Conciliation Project Committee, Honorable Mr. Justice Rajesh Bindal, Chief Justice, Honorable Captain-in-Chief, UP State Legal Service Authority, my brother Masudi, and my brother and sister judges sitting off the dais, my Ms. Ulgul Badiyal, Member Secretary, Mediation and Conciliation Center, learned master trainers, learned lecturers, distinguished guests, and ladies and gentlemen. Thank you is such a prayer that cannot be seen or touched. It must be felt with heart. I feel honored and privileged to get the opportunity to propose a vote of thanks on the 40hrs Mediation Training Program. Words are not enough to thank their constant guidance and support to shape the training program. I, on behalf of Mediation and Conciliation Center, as well as High Court Legal Services Subcommittee Lucknow, and also on behalf of my esteemed brother and sister judges, convey deep regards and hearty thanks to our Chief Guest and Chief Justice as well. Today, my words are not enough to express the gratitude to our Chief Guest and the Chief Justice who graced us with their kind words and for their constant help and guidance that radiated a source of energy within us. We will ever remain grateful to you and we thank you for being with us today. Mediation has a long and a varied history in almost all cultures of the world. The villages of India traditionally rely on the panchayat justice system, where a panel of 5 members mediated and arbitrated disputes. Parties would state their case and effort would be made to reach a consensus. This system was so highly respected that the panches were revered as Panch Parmeshwar. The modern day mediation process is similar to the panchayat system in the sense that it strives for a consensus. It uses the language of silences. Mediation as a process involves a third party assisting 2 or more persons to find mutually agreeable solution to the difficult problems. People make use of mediation at many different levels and in multiple contexts, from minor disputes to global peace talk. There is a vast difference between mediation and litigation. Mediation offers a process by which 2 parties work together, an agreement with the aid of a neutral third party. Litigation, however, is a process in which courts impose binding decisions on the dispute parties in a determinative process. Mediation aims to resolve many of the problems associated with litigation, such as high costs involved, the formality of the court system, and the complexity of the court process. Mediation does not create binding agreement unless the parties consent to it, and the mediator has no say in the outcome. In order to popularize the concept of mediation and to motivate litigants to go for mediation, a district mediation week should be organized in a month. Various programs should be conducted at district and block levels to highlight the need for and benefit of mediation and to educate lawyers and advocates about the concept and practice of mediation. This is an important element of work. Making people aware of mediation being a credible and workable option is important. Lack of awareness often results in lack of utilization of an option. I once again very much thankful to our Chief Guest and Chief Justice, all esteemed brother and sister judges, learned master trainers, learned mediators and members of the registry for making this event a successful one. Thank you all for making this event successful. Thank you.
Now I request all of you to stand up for the national anthem.
पंजाब सिंधु गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जगति तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल कारक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय।
Thank you all for gracing today's inaugural function. I will now request all of you to join us for high tea. I will also request the mediators to assemble again at after the high tea for the introductory session. I will request all the honorable judges also to join us for the training for a little while.